Baik, baik Bapak Ibu, kita masuk ke acara. Ibu Sarah, kita mulai.
Oke,
Baik.
baik.
Selamat siang Bapak Ibu. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk kita semua. Alhamdulillah pada siang hari ini, tanggal 10 November 2025, kita bisa bersama-sama secara daring masuk ke dalam acara kuliah umum yang diselenggarakan oleh program studi Doktor Ilmu Hukum Fakultas Hukum Universitas Trisakti. Terlebih dahulu kami sampaikan susunan acara. Pertama, menyanyikan lagu Indonesia Raya dan Mars Trisakti. Kedua, sambutan sekaligus pembukaan oleh Dekan Fakultas Hukum, Profesor Dr. Randa Siti Nurbaiti, SHMH. Ketiga, paparan oleh narasumber, yaitu Ibu Dr. Siti Sarah Sulaiman. Keempat, diskusi, tanya jawab, dan terakhir penutup dokumentasi. Langsung saja kita memasuki acara pertama, menyanyikan lagu Kebangsaan Indonesia Raya, dilanjutkan dengan Mars Trisakti. Hadirin dimohon sikap sempurna.
Indonesia, tanah airku, tanah tumpah darahku. Di sanalah aku berdiri, jadi pandu hidupku.
Baik, selanjutnya kita memasuki acara kedua kepada yang terhormat Dekan Fakultas Hukum Universitas Trisakti, Profesor Dr. Anda Haja Siti Nurbaiti SIMH, untuk memberikan sambutan sekaligus pembukaan. Dipersilakan.
Ibu Dia, Prodi Doktor Ilmu Hukum. Bismillahirrahmanirrahim. Tentunya saya sapa dulu Ibu Dr. Siti Sarah Sulaiman, narasumber kita yang terhormat dari Malaysia. Selamat datang Ibu Siti Sarah. Namanya sama dengan nama ibu saya ini. Namanya persis dengan nama ibu saya ya. Jadi selamat datang, dan juga walaupun lewat Zoom, mudah-mudahan kita sama saja baik Zoom maupun offline. Kemudian sini Sari Amalia ya sebagai moderatornya. Terima kasih ya sudah mau menjadi moderator.
Iya, Bu Dekan.
Dan ini ada dosen dan juga mungkin tentunya para mahasiswa spesialis, khususnya mahasiswa program Doktor Ilmu Hukum yang saya banggakan ya. Pertama-tama marilah kita panjatkan puji syukur kehadirat Allah Subhanahu wa Ta'ala, bahwa atas perkenalnya kita semua masih diberikan nikmat Islam, nikmat sehat, nikmat panjang umur, sehat walafiat ya, sehingga dapat menghadiri acara yang sangat istimewa hari ini, yaitu kita guest lecture ya, dengan judul ini saya bacakan ya, An Overview of the Malaysian Legal System, Structure, Sources, and Challenge. Nah, ini juga mungkin sebagai bahan perbandingan dari para mahasiswa doktor ilmu hukum ketika kita berbicara legal system itu. Banyak sekali yang kita bisa perbandingkan dengan negara lain ya. Jadi Assalamualaikum warahmatullahi wabarakatuh Pak tadi saya. Ini nggak concern karena ada dua device ya. Hari ini kita berbahagia ya mendapatkan kesempatan mendengarkan paparan ilmiah dari Ibu Dr. Siti Sarah Sulaiman yang dari Malaysia sebagai pakar tentunya berkaitan dengan pengembangan kajian hukum di bidang legal system ya, dan terutama kita melihat dari segi sudut perspektif perbandingan hukum dan dinamika hukum yang ada di antara Indonesia dan Malaysia, karena memang kalau kita melihat disertasi doktor itu memang harus ada perbandingan ya, mau nggak mau kita harus membuka wawasan kita dengan berbagai negara, yang untuk kali ini memang kita memanggil dari ahlinya dari Malaysia ya. Jadi dan tentunya kuliah ini merupakan komitmen Fakultas Hukum Trisakti untuk terus memperkuat kualitas akademiknya, memperkuat jaringan internasional, dan tentunya membuka ruang dialog dari para mahasiswa ya. Jadi mahasiswa, saya berharap ini adalah kesempatan yang sangat berharga untuk bisa berdiskusi langsung dengan narasumber yang ada berkaitan dengan materi yang akan disampaikan oleh Ibu Dr. Siti Sarah. Saya ucapkan terima kasih kepada panitia, terutama DIH yang telah menyelenggarakan acara ini, dan juga tentunya saya sampaikan apresiasi kepada Ibu Dr. Siti Sarah Sulaiman atas kesediaan meluangkan waktu untuk berbagi ilmu dan pengalaman kepada kami semua, termasuk moderator ini ya, mudah-mudahan bisa berjalan dengan baik. Sebelumnya izinkan saya dengan mengucapkan Bismillahirrahmanirrahim, kegiatan guest lecture and overview of the Malaysia legal system structure, sources and challenges ini saya buka. Semoga kuliah ini dapat berjalan lancar dan memberikan manfaat yang sebesar-besarnya bagi pengembangan ilmu hukum dan peningkatan kualitas mutu akademik Doktor Ilmu Hukum. Sebelum saya akhiri, saya tutup dengan pantun. Jalan-jalan ke Kuala Lumpur.
Cakep.
Singgah sejenak membeli kain.
Cakep.
Ilmu hukum kita pelajari
Cakep,
bersama agar keadilan makin terjamin. Ya. Terima kasih.
Luar biasa, Prof.
Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera bagi kita semua.
Baik, terima kasih Ibu Dekan. Untuk selanjutnya kita langsung memasuki acara inti, paparan dari narasumber, dilanjutkan dengan diskusi dan tanya jawab. Untuk itu, selanjutnya acara kami serahkan kepada moderator Ibu Sari Amalia untuk memimpin jalannya acara hari ini. Baik, terima kasih. Silakan Ibu.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Good morning everyone and welcome to our guest lecture. Selamat siang Bapak Ibu dosen, mungkin ada para promotor, rekan-rekan mahasiswa program Doktor Ilmu Hukum Universitas Trisakti. Saya dua bahasa ya, izinkan Ibu Dr. Sarah. It's wonderful to see everyone joining virtually today. And on behalf of the doctoral program Law Faculty Universitas Trisakti, I would like to welcome you again for today's guest lecture with a theme, an overview of evaluation legal system, structures, sources, and challenges. It's an honor for us to have our distinguished guest speaker from Malaysia, Dr. Siti Sarah Sulaiman, who will share her insight and experience with us. And let me share with you the curriculum vitae of Dr. Siti Sarah. 1 minute. Dr. Siti Sarah finished her Bachelor of Legal LLB, International Islamic University Malaysia, with an honors degree, and Master of Comparative Law, MCL, International Islamic University in Malaysia also, and her PhD in 2017 in Planning Law in International Islamic University of Malaysia. So without further ado, we shall start the guest lecture for today. Please welcome Dr. Siti Sarah Sulaiman. The floor is yours.
Okay. Thank you very much, Ms. Sari, moderator for our session today. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera. Pada Ibu Dekan, Ibu Daya, dosen Fakultas Undang-Undang Trisakti, pelajar-pelajar, mahasiswa dan juga undergraduate, postgraduate and undergraduate students. First of all, I would like to say thank you. My gratitude towards Ibu Dekan, and Ibu Daya, and also Fakultas Undang-Undang Trisakti for
Ibu
inviting
Sarah,
me.
mohon maaf, suaranya kecil.
Kecil.
Iya.
Bentar. Okay. Thank you very much, for inviting me to the program, guest lecture, organized by the students, mahasiswa, postgraduate students. Thank you very much for the invitation. Is it clear now?
Masih di mute?
Yes,
Izin, Prof.
it's clear.
Masih di mute, Prof.
Kalau begini?
Yeah, clear. It's clear.
Okay, clear, yeah. Okay. All right. Let me explain first. Okay, my first discussion with Ibu Daya, because I want to know who are going to be my audience. Siapakah audience saya? So Ibu Daya said student PhD, okay, with various background, because my area of research is land law, planning law. And I also teach Malaysian Islamic legal system, Syariah law. Jadi to make sure that all students and audience can appreciate my presentation, so Ibu Daya suggests to discuss about the legal system. Okay, can you see my slide?
Yes.
Okay. Okay, so the title, as mentioned, is an overview of the Malaysian legal system, structure, sources, and challenges. So as an introduction, okay, sebagai pendahuluannya, okay, Malaysia ini terdiri adalah Ibu Daya minta saya berbahasa Indonesia, tapi saya tidak mahir. So I try to speak both Malaysia, bahasa Malaysia and also English. Okay. So as you all know, sebab kita adalah serumpun, okay, Malaysia is neighbouring country to Indonesia. I believe most of you have been to Malaysia, and I think you already observe the legal system, the political aspect in Malaysia. But as an introduction, Malaysia has a unique and multiple legal traditions. Okay, we're talking about the introduction to the structure of the law. So we have multiple legal traditions, okay, which reflect the nation's rich multicultural heritage and complex colonial history. So the introductions, the implementations of law in Malaysia is based on the historical developments, okay, the evolutions of law, the interventions of jajahan, aspek penjajahan, okay, daripada Portugese, daripada English, Japan. So it's resulted in a hybrid system and multi legal traditions, okay. So this hybrid system integrate, okay, three distinct legal framework operating in parallel. And we have the common law tradition inherited from British colonial rules, which forms the backbone of civil and commercial law. And alongside with this, we have Sharia law, which govern the personal and family matters of Muslim, okay, in Malaysia. And we also have customary law, okay. Okay, if we go through the evolution in very brief, okay, we have the pre-colonial period, okay, where we have all at this period of time that we apply the indigenous adat, okay. We have Malaysian customary land tenure, for example, okay, before the colonial period, okay, before the intervention of British in Malaysia, Tanah Melayu, we implement the indigenous adat, okay, or Malay customary land tenure, for example. Since my area is land law, so I give example of what most closely related to me. So one of the example is Malay customary land tenure is the law which was implemented during the pre-colonial period, and also the Islamic law which govern personal matter like marriage and divorce, okay, and also inheritance. And during the British colonial era, okay, we can see the implementations, okay, adaptations of English law to Tanah Melayu, okay, by virtue of the English common law, okay, in straight settlements, federated Malay state, and select. So the law is seeped through, brought by the English to Tanah Melayu, and this is formalized by the Civil Law Ordinance 1956, okay, Civil Law Act 1956, okay. So only law which is suitable, okay, to be implemented in Tanah Melayu at that point of time was implemented and accepted, okay. But law which related to personal matter is still remain with applying the Sharia law, okay. So for example, here when the English bring in their law together, for example, contract law, okay. So our contract act is similar to the English Contract Act. And when we have another example is the planning law, Town Country Planning Act 1976, which we apply now, is similar to the English Town Country Planning Act 1976. So whatever which is suitable to be implemented in Tanah Melayu at that point of time is taken. But whatever law related to the personal, the family matters, that one we apply the Sharia law. And the third evolutions you can see during the post-independence, 1957 until now. So there are various laws being passed, okay, to cater issues, okay. But the most important law, the supreme law of the nation, is federal constitution. And the law passed should be in line with the federal constitutions. And together with that, we have Islamic law and also customary law. Okay, so that is very brief about the evolutions of law in Malaysia. Okay, and now we move on to discuss about the structure of the Malaysian legal system. So basically, the Malaysian legal framework operates on the fundamental principle of separations of powers, okay, enshrined in Article 4 of our federal constitution. So this constitution doctrine divide governmental authority amongst three distinct branches, and each branch has their own responsibility. So these are the three branches, okay, of powers. First is the legislature, okay, the executive, and also the judiciary. They act together, but each one has its own responsibility. And in executing the responsibility and powers, each of these elements should not okay, interrupt each other, and they should act within their own jurisdiction. For example, legislator is the one who creates and amend law through parliamentary process. So our parliament consists of Dewan Rakyat, Dewan Negara, and the Yang di-Pertuan Agong. So here the process of making law is conducted. Bacaan first reading, second reading, and third reading. So the process is done in Dewan Rakyat first, okay. Each new law will be presented, okay, by the ministry portfolio, okay, and it will be debated, okay, at this level. And if it is passed, it goes through the Dewan Negara. The same process will be done, first reading, second reading, and third reading. And if there is no amendment made to it, it will go up and pass by the Yang di-Pertuan Agong with his consent. So this is the power, okay, inherent power of the legislator in making law. And of course, it will be in line with the contemporary issues, okay, with the advance of technology and with the AI aspect. So the law will be developed, and new acts or new law will be passed and tabled in the parliament. Whereas the executive is the one who implements the policy, the law made by the legislator. So here we can see the Prime Minister and also the respective ministries. And as regard to the judiciary, this is the implementations in the court system, where the judge, the lawyers interprets the law and adjudicate dispute independently. So the separation of power will determine the check and balance, so that setiap satu ni tidak akan bercanggah atau melebihi bidang kuasa masing-masing. So this also can ensure equality, okay, and justice, so that the one who is appointed by at the judiciary level should not have any conflict interest with the executive and also the legislature. Okay, so I think by looking into the structure of these separations of powers, somehow or rather it also has challenges as well. There is some critics which says that the appointments of judge is not independent, and there's a lot of issues relating to this aspect as well. Okay, now we move on to discuss about the sources of Malaysian law. Okay. So the sources of Malaysian law are divided into three: written law, unwritten law, and as for me, okay, since we have a dual systems of court in Malaysia, civil court and the Sharia court, So the Sharia law is also considered as the sources of Malaysian law. So I divided into three. Okay, in some books and author, Sharia law is falls under the unwritten law. Okay, but I separate it into three so it can be clearly seen how it relates to the dual system of court in Malaysia, since we have Sharia court and civil court. Okay, so the written law can be divided further into federal constitutions, okay, where this is the perlembagaan negara. In order to achieve independence, okay, this is the most important documents that Tanah Melayu perlu sediakan to see what kind of nations Malaysia is going to be before it obtained, okay, the independence. So these federal constitutions, okay, consists of our rights, okay, and so the separations between Sharia matters and also the civil matters. So basically federal constitutions ini sangat penting, okay. Whatever law passed after this, okay, should be in line with the federal constitution. Anything which is go against the rights, for example, if you can refer via online check the federal constitutions, okay, we discuss about fundamental liberties, okay, starting from part 2. So Article 5 discuss about liberty of the persons. Article 6 discuss about slavery and forced labor. Article 8 discuss about equality. Article 9 about prohibition of banishment and freedom of movement. And we have Article 10, freedom of speech, assembly, and association. So I think Article 10 is the most famous and well-known provisions in federal constitution. Lay person, anyone in Malaysia know about these provisions. Anything go against their rights, they will highlight about Article 10, which is freedom about speech, assembly, and associations. Okay. And another important articles or well-known articles in the federal constitution is freedom of religion. This relate to our challenges later. The issue of conversions is also a big issue in Malaysia. Because this is also rooted from Article 11, whereby it mentioned about freedom of religion. So there's an issue, okay, discussing about the rights to change religion, to renounce Islam. So what is the positions of those who renounce Islam? Okay, because federal constitution has given the rights under Article 11. Okay. So basically, federal constitutions is the foundations of Malaysia, okay, and the law passed must be in line, okay, with the federal constitution. So we also have state constitution. fixture of law in land law matter. For example, we adopt the torrent system, okay, from Australia. Okay, we discuss about indivisibility of title. Ownership of land is by virtue of the title, as the title geran tanah is the evidence which shows that the owner is the absolute owner of land. Okay. But at the same time, we also refer to English law to explain further on certain issue. For example, issue of fixture and chattel. Okay, under the land law, if we want to define what is land, okay, whether it is fixture or chattel. So we apply national land code, okay, for land law matter. The provision is discussed in national land code. Okay, so national land code define what is land. Okay, anything okay attached to the land, okay, built on the land, okay, whether above the land, above the soil or below the soil, that form part of land. The grass, the trees, okay, the mineral, that is land. But the issue is when you build a house, okay, structure on the land, and you attach all the equipment, the furnitures, okay, to the wall, to the ceiling, to the floor of your house, okay, we need to determine whether the items is fixture or chattel. Is the television attached to the wall fixture or chattel, whether it can be removed or not. So the NLC, National Land Code, does not provide detailed explanation what is fixture, what is chattel. Therefore, we have to refer to the English law, okay, by virtue of case Goh Chong Hin. So we need to refer to the English law. So from this, I can say that there is a mixture of law still in Malaysia. And as regard to aspect of land property, when it's involved inheritance, wasiyah of a Muslim, so the Islamic law will be applied. So there is a mixture of law, yeah, when applying for when discussing about land matter. So not only English law, Australian law as well is discussed as the sources. And judicial decision, okay, is also sources of Malaysian law. The previous court decisions, okay, is also the sources of Malaysian law. Like what I've mentioned about the case regarding fixture and chattel, the issue of determining whether the item is fixture or not, whether the underground storage of oil station is fixture or chattel, whether rumah traditional Malaysia is considered fixture or chattel. Okay. And lastly, the unwritten law, we have custom, okay, adat. Okay, adat is also diterima pakai sebagai undang-undang di Malaysia, iaitu kita ada dua, okay, adat pepatih dan juga adat temenggung. So, yang kita pakai di Negeri Sembilan, okay, adat Minangkabau itu, adat pepatih itu diterima pakai sebagai undang-undang, especially related to aspect of tanah, aspect of land, okay. Isu jual beli tanah, isu pembahagian hartanah, okay. So they still apply the adat pepatih. There is restrictions, okay. Siapa yang boleh beli tanah, hanya saudara ataupun members of the luar sahaja has right to buy the property. Okay, so custom also part or recognized law in Malaysia. Okay, and finally we have Sharia law. Okay, because Sharia court is part of the system. Okay, so the sources of law applied implemented in the Sharia court is the Sharia law. So we have primary sources, Quran and Sunnah, and whereas for the secondary sources, okay, the judge, the Shari'i council will refer to the ijma, qiyas, istihsan, istishab, masalih, mursalah. Okay, so all these will be referred to in the and Sharia law applies only to Muslim parties, okay, and only Muslim Shari'i counsel can appear in the Sharia court. Okay, so we move on to discuss to see the hierarchy of court. Okay, as I refer this as civil court since we have Sharia court. Okay, so this civil court. Okay, you can see the hierarchy of courts from magistrate court, session court, High Court of Malaya. We have one. We considered High Court of Malaya and also High Court of Sabah and Sarawak. Okay, because we have West Malaysia, okay, and also Sabah and Sarawak. Okay? And we have Court of Appeal, and finally the highest court is the Federal Court. Okay, so each court has its own jurisdictions. Okay, and we also have special court here. Okay, for Army Court, okay, Industrial Court as well. Okay, so we considered Magistrate Court and Session Court as subordinate court, whereas the superior courts consist of High Court, Court of Appeal, and Federal Court. Okay, so the last avenue for appeal is at the Federal Court level. So whatever decision made at the Federal Court level will bind the lower court and similar cases. Okay. As regard to the Sharia court, okay, we have 3 tiers of level of court. It begins with the Sharia subordinate court, and it go up if there is an appeal going up to the Sharia High Court, and also last and final court of Sharia court is Sharia Appeal Court. Okay. There is a suggestion made by the previous Yang di-Pertuan Agong, okay, which he suggested that Sharia court should have Sharia Federal Court. Okay, but that is just a suggestion made by Yang di-Pertuan Sultan of Pahang. Now he is the Sultan of Pahang. So since Islamic matter is state matter, okay, each state, okay, will manage its religious matter, okay, respectively. So since he is now the Sultan of Pahang, so he suggested that for Pahang there should be a Sharia Federal Court as a respect to the system of the Sharia court. Okay, but that is just a suggestion. Okay, we will wait to see about the development. Okay, because if Pahang has Sharia Federal Court, so other states should or will discuss, okay, about the same things to make it synchronized and uniform. Okay. Okay. So that is basically a very brief discussions, okay, overview of the structure, okay, the sources of law in Malaysia. Okay. I try to relate, okay, the structure, the sources of law, okay, with the challenges. Okay, it comes with the great challenges. Okay, especially you notice that I highlighted so much about Sharia court because that the challenges come from that aspect. Okay, there are many other challenges. Okay, as I mentioned about the appointment. Okay, of judges, okay, about equality, about human rights, okay. But for these sessions, I try to highlight one important issues, okay, related to Sharia court, okay, as majority of community in Malaysia is Muslim, okay, that is the religion of the country. So it becomes a very sensitive issue when you talk about jurisdictions of Sharia court, powers of Sharia court. So that become the important challenges that I try to highlight at least one today during these sessions. Okay, the challenges come from the jurisdiction between the civil court and the Sharia court. Since we have dual system, to manage both these systems to be in line, okay, is a very big responsibility because these are separate institutions, okay, separate judges, separate law to be applied in both these courts. So there are rooms for conflict and clashes. Okay, and furthermore nowadays, okay, people are more that is options, whether you want to be a pious Muslim or you want to be more liberal, that add on fire to the issue and the challenges. Okay, because there are one group who says that it's fine, okay, and the other group which uphold the Sharia law strictly. So that become one of the challenges that we are facing. I think every year, okay, there are issues regarding the implementation of Sharia court in Malaysia. Okay, as you have seen the different court system, Sharia courts, okay, with its hierarchy, and the civil court with its own hierarchy. So it comes together with specific jurisdictions. High court, civil court, we only look into matters which does not include Sharia matter. So it's easy to say that way. All the matter relating to Muslim will go to the Sharia court, right from betrothal, marriage, divorce, hadana, okay, about custody, about children, okay, maintenance, about Sharia offenses like zina, okay, halwat, okay. So that one falls under Sharia matter, okay, and it falls under states, okay, regulations. Other than that, all the aspect of offenses, okay, like murder, okay, like contract, um, land matter, it all falls under the civil court. Okay, so that is the demarcations of powers and responsibility and jurisdiction. But still, there are challenges to it, and there is still conflict of jurisdiction happen between the civil court and the Sharia court. Okay. For example, here okay, this is what I mentioned, the state list. Okay, list 2 under the 9th schedule of the Federal Constitutions. Okay, list down the matter or list this related to Muslims. Okay, so it lists out areas of Islamic law and personal matters. Okay, family law matters of person professing the religion of Islam. And this also limit the jurisdiction of the Sharia court only to cover person professing the religion of Islam and in respect of areas listed in the state list. Okay. And in respecting the jurisdiction of court, okay, untuk menunjukkan Syariah law itu diterima pakai, okay, and is the level of Syariah court, okay, is put at the higher level. After the amendment to the Federal Constitution, okay, in Article 1211A, it was clearly mentioned that stated that okay, jurisdiction of civil court, okay, it does not include matters falls under the Sharia list. Okay, so if the civil court only can hear matter, okay, with respect to the civil aspect, and it will not interfere and encroach the power of the Sharia court. Okay. But having said this, okay, there is a sample of cases, okay, which shows otherwise. There is still conflict, okay. For example, in the aspect of conversion, okay, so this is like a very sensitive issue in Malaysia, okay. So we can see that in Malaysia, okay, we have enactments, okay, passed at the state level since Islam is state matter. So each state has its own enactments governing matters of Islam. Okay. So as regard to conversion to Islam, okay, masuk Islam, okay, all state enactments and the Act for federal territories have express provisions giving the Sharia court the jurisdiction to deal with cases of conversion to Islam. So when the provision is clear, so it shows that state, okay, has clear power to discuss about issue conversion. Okay, so it shows that the state enactments have the state executive legislative council, okay, has the power to enact any provisions relating to conversion of Islam. Okay, the process, cara masuk Islam. Okay, so it's something which is the power of the state authority. Okay. As regard to conversion out of Islam, perkara ini tidak diterangkan secara detail. Okay. Apakah hukuman ataupun proses conversion out of Islam, only certain state has specific mention about the process to renounce Islam. Okay. So this is again a very sensitive provisions, because it can be said that by having the process, it is criticized that it's like memberi galakkan, memberi jalan untuk murtad. Okay. But when the provision is not mentioned in the state enactment, it gives difficulty for the judge, okay, or difficulty in determining which court has right to hear matter of conversion. Sebab untuk keluar Islam perlu melalui proses, okay. It need to be done, okay, properly, and need to be recorded, okay. Because it relates to the aspect of status of religion in the IC, okay. So it's become complicated. So if the provision is not mentioned in the enactment, it can be said that Sharia court has no jurisdiction to hear the conversion matter. Therefore, should it goes to the High Court, the civil court? Okay. But that is not right, because the persons who wants to renounce Islam is Muslim. So a Muslim must go to the Sharia court. Okay. So now when we discuss about this matter, okay, one example that I can share with my student is the Negeri Sembilan State Enactment. Okay, in Negeri Sembilan State Enactment, it mentions very clear the process to renounce Islam, from the process of applying to the Sharia court, okay, proses untuk apa tu, ada banyak proses lah yang perlu dilalui, okay, sebelum applicants betul-betul declare sebagai murtad, okay. Tapi tak banyaklah state yang ada special provisions on conversion, okay. And another aspect is punishment. Should punishment be stated in the enactment? Apakah hukuman yang sesuai? Apakah hukuman untuk orang yang murtad? So that is also a very sensitive issue, because of course there will be a group of NGO which highlight that that punishment, that hukum is against the rights enshrined under the federal constitutions. Okay, but this is something that become a never-ending discussions, never-ending issue with as regard to conversion. Another aspect about conversions as to the record of the conversion is whenever one party died, okay, and it was found out that he is already murtad, okay, friends said that he is already renouncing Islam, he did not fulfill the duty as a Muslim, but there is no record or evidence which shows that he already renounced Islam. So the issue that the government or the state has to solve is how to bury the body ikut Islam ataupun the current religion. Sama juga dengan aspek conversion to Islam, okay. When the persons, okay, convert to Islam, but he did not go through the process, okay, and he died, okay, and nobody know about his the current faith, okay, except one or two friends, okay. So can the evidence from friends, okay, be accepted, okay, to say that he or she is already a Muslim? So these are among issues that we are facing, okay, in Malaysia. On and off, okay, ada je isu ini. Okay, another challenge, okay, is as regard to the unilateral conversion of minor children by a converting spouse. This also results from the dual system of court, Sharia court or civil court. The issue always be to bring the matter to Sharia court or to the civil court. Okay. So another aspect is the unilateral conversion of minor. Okay, so this one resulted from a couple who married, okay, in their own religions, okay, a non-Muslim couple who married, okay, based on their religion. So based on the example of cases here is based on the Hinduism, okay, ceremony. And afterwards, okay, after 2-3 years of marriage, okay, one of the spouse decided, okay, to convert to Islam, to change religions, okay. So based on observations, most of the time, the male, the husband who converted to Islam and leaving the wife behind, okay. So there was an issue regarding that, okay, which court to hear the matter of maintenance, custody of children, okay, because the mother is still remain with the Hinduism, but the husband, the father already become a Muslim. So to hear the matter of maintenance, to hear the matter of custody, okay, which court will hear it? Civil court or the Sharia court, okay? So that is the conflict, okay? Konflik yang ini when the father decided to convert the minor children, okay, to Islam, okay, is it right? Okay, can that be accepted because this is minor underage, and he, of course, it's children, okay, he didn't know, okay, what is Islam yet, okay, so the father bring the children to Islam, so the mother contested and said that the conversion is illegal because it was done not with the consent of both parents. So we have to discuss the issue now, okay, whether consent from both parents is important, okay, in deciding the conversion of minor children. So we have 3 cases now, okay, to discuss about this issue. So finally, at the federal court level, it was decided that both consent of parents is needed in order to convert the minor. So it shows that mother still has right to determine the religions of the underage children. Okay. Okay. So this is very it's sad to see because it involves children. Okay, children become the victim in these situations. Okay, in all cases, okay, because it's a problem of parents. Okay, but the impact is on the children. Okay, dia nak ikut siapa. Okay, and most of the time ada issue anak di-kidnap, dibawa lari and got separated from the mother. Okay, so these are the most heart-wrenching challenges, okay, as regard to the institutions of the court because the impact is on the children. Okay, another problems, okay, that affect us is about the overlapping criminal offences, okay, at the federal law and the state enactment, okay. So since we mentioned about the amendment to Article 121, okay, we have Article 1211A. The effect is special jurisdiction given to the civil court. Okay, civil court ada their jurisdiction. Sharia court has its own jurisdiction. Okay, and federal law can make the law relevant to the aspect, and state enactment, okay, state executive council, legislative council also has power to make law at state level pertaining to Islamic matter. Okay, so masing-masing dah ada bidang kuasa masing-masing. Okay, but recently some of the provisions in the state enactment has been challenged. Okay, so it is said that the enactment, the state legislative council has no power to enact that aspect of law. For example, issue of liwat, okay, which overlap with the provision in section 377A and section 377D of Penal Code. So liwat has been mentioned in Penal Code, which is the federal law. Okay, at the same time, liwat is also mentioned at the state law because liwat is like Shariah matter, okay? So there is an overlap. So in the case of overlapping, which law prevail? whether the federal law or the state law. Another example is gambling. Okay, so because gambling appears to overlap with the provisions in Section 6 and 7 of Common Gaming House Act 1953, this is federal law. But gambling also relate to the aspect offences of Muslims, sebab orang Islam kan tidak boleh berjudi. So it falls under the state enactment. So this law has been challenged as against the federal law. Recently in the case of Nik Alin Zurina Nik Abdul Rashid and Kerajaan Negeri Kelantan. So at this point of time, state enactment which has been challenged baru di Negeri Kelantan. Okay, so when this happened, you can see the aftermath, the after effect of it. When the law in Negeri Kelantan has been challenged, so we are afraid that there is also another they are trying also to challenge the law in other state as well, because that dia dah mula kan, it already started with one Kelantan, one state, maybe they will try to see another provision in other state. But so far, as of now, tak ada lagi. But this is the precedent. So precedent always has the follower. So this is the starting point. So in this case, this was a petition filed by the petitioners, at the federal court, seeking declarations that all these provisions, the 20 provisions of the Kelantan Sharia Criminal Code enactment, are invalid and hence null and void on the ground that the legislator of the state of Kelantan, has no power to make those provisions, because it's overlapped with the federal law. So the petitioner's ground for challenging the validity of the impugned provisions were beyond the legislative competence of the state. Because the matter is already mentioned in the federal law. So bila ada overlaps, so the federal law will prevail. And it is said that, in the court, it's highlighted that most of the provisions related to criminal law, criminal offences in state, related to matter of public concern, peace, order, security, morality, health. So this is something that should be under the jurisdictions of the federal, not the state. For example, false claim, destroying or defiling places of worship, selling or giving away child to non-Muslim or morally reprehensible Muslim, sodomy, sexual intercourse with corpse, sexual intercourse with non-human, words capable of breaking peace, sexual harassment, and other list of example. So these are provisions stated in the Kelantan enactment, which also found in the federal law. So there is so the question is whether the state has the right and power to legislate all these matters which is related to the peace, order, security, and this is supposed to be under the federal government power. Okay. So these are among the issues that I can share as regard to the challenges to the institutions of court, civil court and the Sharia court. There are other issues and challenges as well, as to for positions of fatwa. What is the position of fatwa? Is it acceptable? Should it be recognized in the civil court or not? As for Sharia court, fatwa is acceptable and part of the sources, sources of the Sharia law as well. But can fatwa be used as a sources, in the civil court? When we discuss about issue of anak luar nikah, and also, do we have time? Can I continue? Can I discuss a bit about the fatwa ni?
Yes, I think we still have another 10 minutes. It's possible.
Okay, thank you. Okay, as regard to fatwa, fatwa is also sources of the Sharia law. No problem at the Sharia court. But we have a case, okay, in the civil court, okay, pertaining to the issue of applications of the parents, okay. Ini berkaitan dengan anak luar nikah, okay. Jadi according to the Syariah law, anak luar nikah tidak boleh dinasabkan kepada ibu dan kepada ayahnya, okay. But this father, okay, after realizing his mistake, okay, and he recognized the children, okay, as his own children. Cumanya dilahirnya apa ni lah kan, consider sebagai anak luar nikah. Jadi namanya bila dilahirkan, the name in the birth certificate should be A binti Abdullah, okay. That is the rulings, okay. But this father would like to petition, and he wants his name to be related to the daughter. Okay, so dia nak nama dia sendiri appear di dalam birth certificate. Okay, so in solving, okay, in making decisions at the civil court level, fatwa is used and referred to. Okay, so the question is, can fatwa be referred to in the civil court? Is already answered. So fatwa berkaitan dengan applicant, berkaitan dengan isu Islam, is recognized and can be accepted at the civil court. Okay. Sebab isu ni tentang isu nasab anak luar nikah, and kadang ada isu yang macam samar-samar kan, isu paternity, adakah syariah court yang akan dengar ataupun civil court. Okay. Okay, another last challenge is issue of halal certifications. Okay. Though that's not something that we brought to the court, okay, but it's an attack to the Islam institutions, okay, Majlis Agama Islam, Jabatan Agama Islam, okay. The issue of halal in Malaysia is also another ending issue. Recently, we were faced with this issue of list of food, cafe, restaurants, okay, listed by Muslim Choice, okay, Muslim Choice, okay. Dia senaraikan nama restoran, okay, which is according meaning that it's a Muslim choice, meaning Muslim can go and it's halal, but there is no halal certification by JAKIM in Malaysia. Each premises, food premises, okay, must have halal certifications, okay, showed in front of the shop, okay. But some other places, okay, they do not have JAKIM certification, okay, but they are listed under the Muslim choice, okay. So the questions, okay, the validity of the list given by the Muslim Choice, and it was found out that Muslim Choice, okay, the members in the management of Muslim Choice are mostly Chinese and not Muslim. So that is something we questions, okay, about the list, okay. So that is among other challenges, okay, that I can share with all the audience, okay. And you can notice the challenges is closely related to the aspect of Sharia courts and Sharia institutions. Okay. Okay, so I think that's all, Miss Sari. Okay, for my presentations, I end with thank you very much and terima kasih.
Okay, thank you so much, Dr. Siti Sarah, for a very engaging and enlightening presentation. Okay, now we're going for a Q&A session for 20 and 25 minutes. And I can see there is one participant who already sent the question through chat board. Can I read the question, Ibu Doctor? From Henry Fran. Thank you, Dr. Siti. My name is Henry. I would like to clarify about National Land Code. would the national land code be considered as legitimate federal law, or each state can have their own variation of land code? Thank you. Henry Frantia.
Okay. Thank you, Henry. Okay, as regard to land matter, it falls under the federal laws. Okay, land matter is a state law. Okay, but national land code is promulgated and passed in order to unify all the law passed at the state level. Okay, so based on the historical development, okay, of land law, each state has its own law. Okay, it start with the enactment. Okay, but too many laws, okay, will make the implementation of land law be chaotic, okay, and not systematic. Therefore, the national land code was passed in order to unify all the law, the segregated law, and to have one uniform land law. Therefore, it is called National Land Code. Okay, so though land is state matter, but in managing the land, okay, all state will refer to this one code, which is National Land Code. Okay. So they cannot have a variation of land code. There is only one national land code, and the land land matters, okay, will refer to national land code.
Okay, any other participants are welcome to type questions. Okay, from Henry. Thank you, Dr. Siti. Any other participants to type questions through chat box, or raise your hands, or speak directly to Dr. Siti, Sarah? Maybe from the student, from Alvin Sulaiman to
Siti Sarah Sulaiman.
Ah,
Alvin
okay.
Sulaiman to Siti Sarah Sulaiman.
Okay. And Bapak Purnomo, silakan.
So, good afternoon, Dr. Siti Sarah.
Afternoon.
Yeah, my name is Alvin Sulaiman. So, I'm from batch 27 of the doctoral program in law at Trisakti University Indonesia. So, I find your presentations on an overview of the Malaysian legal system very, very insightful. So from your explanations, I noticed that the Malaysian legal system shares many similarities with the Indonesian system, particularly in how both countries accommodate what Professor M.B. Hooker called multiple little traditions. So it's blending elements of common law, Islamic law, and customary law. So, and my question is, how does Malaysia manage potential conflicts or overlaps among this plural legal tradition in practice, especially when cases involve both civil and Sharia jurisdictions? And what lessons might Indonesians learn from Malaysia's approach to maintaining coherence within such a pluralistic system? I think that's my questions. Thank you very much, Dr. Siti.
Okay, thank you for the questions. Okay. Yeah. Based on the cases that I've shared, okay, as regard to issue of conversion, issue of unilateral conversion of minor, okay, issue of effect of conversion, okay, to Islam on the children's, okay. We can say, I can say that how Malaysia react to it, okay, to solve the issue is by way of amendment to the act, amendment to the law itself. Okay, for example, to the issue of divorce, okay, conversion to Islam, okay, to the marriage, okay, because this is the case where I mentioned about the party who married okay, non-Muslim party who got married under their respective law, okay, the Hinduism, okay, and afterward only the husband, okay, convert to Islam. So that and under for Muslim, okay, that has already break up the form of the rukun nikah, the marriage itself, okay, it break up the marriage, okay. As for the wife who remain as a non-Muslim, okay, their marriage is still intact. For her, under the record, in the record, the marriage is still intact. She is still a wife to the husband. But whereas for the husband who already converted to Islam, okay, so he's already a Muslim. For him, there is no more marriage because for rukun nikah, one of it is a Muslim, okay. So now Malaysia has, I can say, we has settled the issue where there is an amendment made to the Law Reform Act, okay, whereby the law provides that the husband, okay, has to solve the matter first, okay, in terms of maintenance, in terms of custody. Both parties can go to the civil court. Okay, remember before this I mentioned Muslim Sharia court govern only Muslim, civil court govern non-Muslim. There is a separation. Okay, so after the amendment made to the law, okay, so now the husband who converted to Islam can appear in the civil court, solve the issue at the civil court first in terms of maintenance, custody, okay, then he can move on with his life, okay, as a Muslim. So I think that is as we can see, that is the solutions that we can find, because even under Islam, okay, you have to the responsibility, okay, you need to show that as a good Muslim, you have to show your responsibility as a husband. Even you have converted to Islam, the remaining responsibility must be settled first before you move on and open a new chapter in your life. Okay. So I can say that how to solve the matter, none other than the amendment to the law. Okay. That would bind both parties. Okay. And another thing is also by way of law as well. The tools is legal tools. Okay. When there is no provision, clear provisions as regard to conversions, make it clear and mention it in the provision so it's very clear about the process and procedures. As regard to conflict, okay, overlaps of federal law and the Sharia law, okay. So it's high time for each state to look back into the enactments. What are the provisions that need to be clear, okay? So my answer is to solve the issue is also by way of the amendment to the law.
Okay, thank you, Ibu. Next question from Bapak Purnomo. Silakan, Bapak.
Thank you, Prof. First of all, I would like to inform that my name is Purnomo and I'm of the philosophy diploma of Trisakti University Jakarta. And I'm with this discussion is just very necessary to us to ask about in the Malaysian system of legal system. And before I speak to you that before I ever to stay in Malaysia about 2 years in Malaysia in Port Langport, and before I joined with the Malaysian company. So about 2000 I think 2017 before this there is a case of King Chonam murder in Malaysia, and before that is there is what is it the Indonesian people to do what there is murder in Malaysian port. my ask to Prof. Siti Sarah is how how to how to handle about the legal uh, because the murder from not Korea, but what is it? And the doing of the deaths is from 2% of Indonesia. How to explain about it about the legal standing in Malaysia, Prof. Siti Sarah. Thank you.
Okay, let me try to understand the question. This is about murder case.
Yes.
It happened in Indonesia or in Malaysia?
It's meant about the implication about implication for the foreign national and the international because uh, according to uh, my knowledge, there's Malaysian written full criminal jurisdiction of any crime committed within its territory, regardless of the nationality of the victim of uh, a perpetrator. So how about it? It's mean that
Okay,
however West cases it's a diplomatic uh, uh, personil intelligent agent. Yes. How about it, Madam?
Okay, can I help here? Bapak Punten, ini kasus apa Bapak? Pembunuhan?
Iya, yang ini mengenai yang King Jong Nam itu kan yang
yang
ya itu kan
Malaysia.
yang Malaysia kan itu kan ada dua kalau nggak salah itu pelakunya itu kan ada di Indonesia gitu kan. Bagaimana mengintegrasikan dalam sistem hukum di Malaysia yang begitu kalau dari dijelaskan oleh Ibu Siti Sarah itu kan begitu sangat ketatnya gitu kan
Oke.
untuk mengakomodir itu kan berarti kan harus ada keseimbangan hukum
Oke.
antara sistem hukum di Malaysia dan serta hukum secara internasional.
Okay. Hukum Malaysia is about international law and national Malaysia national law in regards of kasus apa Bapak? You remember the guy from North Korea
Pembunuhan yang ada ya
murder in
ya
airport? I remember that.
yang di tahun kalau nggak salah itu tahun 2017 ya.
Siti Aisyah, I think regarding Siti Aisyah, the Indonesian nationals. Do you know about
Yeah.
it, Dr. Sarah?
Iya.
Okay, I'm sorry if I cannot remember the criminal law case. But this is these are two things, one Korean and one Indonesian.
Yes, exactly. Yeah.
Okay. So the Korean died in the Malaysian airport.
Yeah.
And
The victim is North Korean, I guess. Died in KLIA. And one of the culprit is Indonesians, and I don't know. Another one is satu lagi orang apa ya Pak ya? Saya lupa.
Asia itu yang pembantu rumah itu ke?
Yeah, and then what happened is, as far as I concerned, they taking back the Siti Aisyah back to Indonesia, and then to be execute, not execute. I mean to be trial in Indonesia.
Okay. Let me be honest. Okay, I'm not very
You're not really
familiar
aware. Yes,
about
you're not
not familiar with the aspect
international.
of criminal law and international law. But as
Uh,
far as I'm concerned, okay, when the murder took place in one country, okay, so the law in the country will apply. But of course, there is aspect of it's how you discuss and negotiates with the country of the persons who being charged, okay, with the murder case. Okay.
yeah.
diplomatik, hubungan
Yes.
diplomatik itu pun memainkan peranan juga. Kalau ikutkan undang-undang for murder, kalau di Malaysia memang we have, all country has the law governing the murder part. Okay, so we have penal code. But sekarang ni isunya berlaku di port, berlaku di KLIA, dan boleh tak diekstradisi ke negara asal, so that international law will apply.
Yes, that's true. Okay, I think in this case, diplomacy playing its role very big.
Yeah.
Okay, Bapak Purnomo, itu jawaban dari Ibu Siti Sarah. Semoga cukup menjawab. Next question
Terima kasih.
comes from Ibu Rani, ya Ibu, Rani Purwanti. Silakan Ibu.
Baik, terima kasih. Selamat siang Mbak Sari Amalia. Selamat siang Ibu Siti Sarah Sulaiman. Good afternoon. I'm very pleased to have discussion with you today. My question is, as we know, Malaysia applies a dual legal system in which is common law serve as a primary foundation of the national legal system, while Sharia law applies specifically to a Muslim citizens in matters of family law, inheritance, and morality. So because we are a PhD students, in the context of comparing the legal system between Malaysia and Indonesia, and as we know, Indonesia use a civil law system, should the analysis focus in a dominance of common law as national legal framework, or on Sharia law as a subsystem, which is reflect Islamic identity? That's my question. Thank you very much.
Okay, thank you, Rani. May I know your area of research, your PhD research?
PhD research is about the parliamentary threshold. Parliamentary
Okay.
threshold is what we call ambang batas parlemen. Yeah, we research about the parliament for pemilu legislatif, is like that.
Okay. Okay. When this is just my suggestions.
Okay.
If you want to compare with Malaysian legislations, okay, the parliament in Malaysia, the prime
Tadi
area
cari ya. Nini
the main discussions or point of reference should be the federal law itself, okay? But then since Sharia law is part of the systems, okay, you may want to discuss as well what is the relevance of how the parliament or federal law, the impact of having Sharia law system goes hand in hand or parallel with the federal law. Cuma the main focus is the federal law itself.
Federal law, okay.
Okay. Sebab
It's not
nanti
Sharia law. Yeah,
because
okay.
nanti there are so many things that you need to discuss on the Sharia part.
Oh.
So you have to limit your comparative discussions. You may want to mention, okay, but however, my research is only limited to discuss on the federal law aspect. And on your part, on the Indonesian part, are you going to discuss on the Sharia things?
No, I think.
Okay.
Okay.
So it's good to focus on the big discussion on the federal law.
Yeah.
But you just mentioned the system. That Malaysia has dual system,
Dual
but
system.
you will limit to refer only the federal law.
Federal law. Okay.
Boleh
Thank you.
juga macam tu.
Okay. Thank you.
Okay.
Ibu Siti Sarah.
Sama.
Okay, Ibu, I think we have a follow-up question from Henry. I think he likes you so much here, the questions. He keep asking, where is it? If I may have one more follow-up questions, granted that land code fall into federal law and applicable throughout the country or states, since Malaysia also recognize common law which focuses on judicial precedents, judgment law, how would a lower court determine their ruling? Would they follow the federal law as is or the judicial precedent, which is more recent? Thank you.
Oh, okay. Okay. Maybe his PhD research is on land, Sari.
Yes, I think so. It's
Okay.
good then.
Yeah, because it's very rare to have scholars who students who want to discuss about land law, environmental law, not glamour. Okay, as to these questions, okay, federal law. Federal law is state law is the types of law. Okay, so when you relate to land matter, okay, judicial precedent applies. There is no problem as to refer to national land code or to refer to judicial precedents. There is a need to refer to the NLC to see the provisions to discuss about the procedure. For example, process of alienation, process of registering, transfer, or charge. Okay, that the process is stated in the NLC that you have to refer to that. Okay, land office will refer to that. Council will refer to the NLC. There are cases where it need to be solved by referring to the judicial precedents. For example, that I mentioned about determining whether the item is fixture or chattel. Okay, that one is not mentioned explained in the NLC. The definitions of fixture or the test to determine whether item is fixture or chattel. So we refer to the English law. So precedence, okay, is applied here. Okay, fixture chattel, for example, charge. Okay, if you have a factory on a piece of land, okay, that factory form part of land. If you want to buy the property, the amount estimated price of the land is the together with the factory. And if in the factory there is machineries attached to the floor of the factory by bolt nuts, cemented very deep in the structure of the factory. So you suddenly you charge the land to bank, okay, and you cannot pay the loan, so bank take over the your property because you secure the land. Okay, you secure the land as a security. So when you apply for loan and you cannot pay the loan, bank will take over the secured land. Okay, so what will happen to the machineries attached to the factory? Okay, can the bank only take the factory and land, and what happened to the machineries? Or vice versa, can the bank take the whole things in the factory, okay, together with the machineries? So the law of fixture and chattel is applied here, okay, because the owner of the machineries, okay, let's say the machine was bought on hire purchase. To make the thing more complicated, the machineries was bought on hire purchase with another company. So is it fair for the bank to take over the machineries, okay, belongs to company A, for example, whereas the loan, okay, the security for the loan is the land itself, okay? What happened to the machineries on hire purchase? So the law of fixture and chattel is applied here. The NLC, the National Land Code, does not mention the test to determine fixture and chattel. So we refer to the English law, Holland and Hodgson. Holland and Hodgson explain the test to determine whether the item is fixture or chattel. And in Malaysia, by virtue of case of Goh Chong Hin, we adopt the test mentioned in the case of Holland and Hodgson. So judicial precedents apply here whenever there is no explanations provided by the legislation or NLC. Okay.
Okay, wow, it's very, very, oh, thank you so much, Dr. Siti. It's very, very good. It's very, very thoroughful answer, Dr. Siti. Thank you so much. Okay, I'm really enjoying also your answer. Also, I'm not into land law.
You are
Okay.
not?
No, I'm not. I'm into international law, actually.
Okay, it's
Okay.
good.
Okay, thank you. Okay, so anyone who have any question or Ibu Daya, Ibu Daya, shall we close the session? Or we still have time here, Ibu Dia, Mbak Dia?
Kalau memang tidak ada yang didiskusikan atau dipertanyakan kembali, mungkin kita tutup ya Bu Sari ya.
Okay, baik. Okay, I think we come to the end of the session. Ibu Dr. Siti Sarah, thank you so much for all the participants. Thank you again, Dr. Siti Sarah Sulaiman, for your inspiring lecture today. We have learned so much from your insight into Malaysia's legal system, its structure, sources, and challenges. On behalf of doctoral program in law, Faculty of Law, Universitas Trisakti, we sincerely appreciate your time and contribution. We also thank all participants for joining and actively engaging in today's session. May this event strengthen our academic collaboration between Indonesia and Malaysia. Okay, before we close, we'll officially today's session, let's take a group photo, everyone together. Please turn on your cameras. And kita nggak bisa capture. Saya nggak bisa capture ini. Oke, udah siap ini Pak Sutrisno. Oke. Oke, sebentar. Mas Boy.
Baik, izin Ibu, Bapak,
Ya.
izin buka video.
Kamera, buka kamera ya Mas Boy.
Ya. Izin 1, 2, 3. Baik, terima kasih.
Terima kasih banyak. Sampai ketemu everyone.
Terima kasih,
Thank you very
Dr.
much.
Sarah.
Terima kasih.
Terima kasih Mbak Sari, Dr. Sarah.
Assalamualaikum warahmatullahi wabarakatuh.
Salam.
Assalamualaikum
Terima
warahmatullahi
kasih.
wabarakatuh. Terima kasih.
Waalaikumsalam. Terima kasih Bu Sarah.
Terima kasih
Terima
Bu
kasih
Dia,
Bu
Bu
Sarah,
Gendes.
Bu Sari.
Terima kasih sama-sama Mbak Gandes.
Iya, terima kasih Mbak Sari cantik.
Saya belum isi daftar hadir. Makasih Mas Boy.
Iya, terima kasih.
Terima kasih Pak Boy. Terima kasih.
Terima kasih Pak
Ya,
Purnomo.
Pak. Makasih. Bukan Des, main keren aja.
Hah? Ya bener nih, Pak Purnomo nih ngerayu aja nih.
Makasih, makasih.